Hey, Sheila here. How is everybody? How is your morning, your night, your evening, wherever you are? Listen. So I don't know if any of y'all hear about Kouri Richins. I'm sure you have heard of her. She was the Utah woman who was accused of murdering her husband. Supposedly, allegedly, she poisoned him with some fentanyl. She gave him some Moscow mules, laced his drinks, gave it to him, and I guess he took a nap. So she was arrested. She was arrested, and she was charged with criminal homicide and aggravated murder in May of 2023. She has pled not guilty. Um, she did publish. She self-published a children's book titled "Are You With Me?" and it was about coping with grief and the loss of a father, which gained significant media attention. She promoted the book on television and radio shows before her arrest. There's videos out there of that. They are quite interesting to say the least. In addition to the murder charges, Kouri is facing numerous new charges related to financial fraud. My mouth is really dry. Hang on. What I was saying, now that my mouth is not dry anymore, the charges were related to financial fraud. They include mortgage fraud, forgery, issuing bad checks, money laundering, communications fraud allegedly committed in the months leading up to her husband's death. The prosecutors claim she used power of attorney to obtain a $250,000 home equity line of credit on her husband's premarital home without his knowledge and funneled the money into her real estate business. Court documents also suggest she was facing severe finance difficulties and opened life insurance policies on her husband, totaling nearly $2 million right before his death. So, I think she had a plan there. That's my opinion. And she has allegedly been charged with these crimes. So, there's been delays, the change of attorneys, appeals, and there was appeal regarding a change of venue. It's currently scheduled to begin in February of 2026 with the jury selection starting on February 10th. So her defense attorneys are maintaining her innocence. So let's see. I know this is kind of bright, and I'm sorry about that, but I don't know any other way to make it a little darker. So that's another thing I'm going to have to learn. So these were filed June 27th is when these were filed with the Summit County, state of Utah. It's the Third Judicial Court. Court Darden Richins. Undersigned prosecutor states on information and belief that the defendant either directly or as a party committed the crimes of 1. Mortgage fraud in violation of Utah Code 76-6-12032A, a second-degree felony, as follows to wit, that on or about June 29, 2021, in Summit County, state of Utah, the defendant did, with the intent to defraud, knowingly make any material misstatement, misrepresentation, or omission during the mortgage lending process, intending that it be relied upon by a mortgage lender, borrower, or any other party to the mortgage lending process. The value of the property, monies, or things obtained, sought to be obtained, is or exceeds $5,000. So there was that one. And then she has a second one that was on August 2nd, 2021. And it is the same with defendant did with the intent to defraud, knowingly make any material misstatement, misrepresentation, or omission during the mortgage lending process, intending that it be relied upon by a mortgage lender, borrower, or any other party to the mortgage lending process. The value of the property, money, or thing obtained or sought to obtain is or exceeds $5,000. That was August 2nd. She has another one, count 3, mortgage fraud, August 12th, 2021. Again, mortgage fraud, count 4, on or about October 13th, 2021. Same count, same charge. Mortgage fraud, Count 5, on or about November 23rd, 2021. Same count, value of property, money, or thing obtained or sought to be obtained is or exceeds $5,000. Count 6 is forgery in violation of Utah Code 76-6-5012BI, a third-degree felony as follows to wit. That on or about June 9, 2021, in Summit County, state of Utah, the defendant did, with the purpose to defraud someone, make, complete, execute, authenticate, or utter a writing so that the writing or the making, completion, execution, authentication, or utterance purports to be the act of another person, whether that person is existent or non-existent. Count 7, forgery in violation of Utah Code 76-6-5012BI, a third-degree felony as follows to wit, that on or about August 2nd, 2021, in Summit County, state of Utah, the defendant did, with the purpose to defraud someone, make, complete, execute, authenticate, or utter a writing so that the writing or making, completion, execution, authentication, or utterance purports to be the act of another person, whether that person is existent or non-existent. So, count 8 is also forgery, August 12th, 2021, same thing. Count 9, forgery, same thing, October 13th, 2021. Count 10, forgery, on or about November 23rd, 2021, same thing. Count 11 is issuing a bad check in violation of Utah Code 76-6-5052AI, a third-degree felony as follows to wit, that on or about August 28, 2021, in Summit County, state of Utah, the defendant did issue or pass a check for the payment of money for the purpose of obtaining from any person, firm, partnership, or corporation any money, property, or the other thing of value, or paying for any services, wages, salary, labor, or rent. The defendant knew the check would not be paid by the drawee. Payment was refused by the drawee. The check made or drawn on the state of Utah is or exceeds $1,500, but is less than $5,000. So again, that was issuing a bad check on August 28, 2021. And it is the same violation, but this date is October 12th, 2021. Same charge, same wording. Charge 13, issuing another bad check on November 11th, 2021. Same thing. Was drawn in the state of Utah, is or exceeds $1,500, but less than $5,000. Count 14, issuing a bad check in violation of Utah Code 76-6-505281, a second-degree felony as follows to wit. Okay, so these first ones were third-degree felony because, as you see, they were exceeded $1,500 but less than $5,000. So when we get down here to this, count 14, this is the same thing, November 12th, 2021, but the payment was refused by the drawee. The check was made or drawn in the state of Utah, is or exceeds $5,000. So therefore, that's why this is a second-degree felony. And this count 15 is issuing a bad check, violation of Utah Code 76-6-5052AI, a third-degree felony, because this one is or exceeds $1,500 but less than $5,000. Count 16 is on or about December 20th, 2021. Is a second-degree felony because, again, this one is or exceeds $5,000 also. Count 17 is a second-degree felony because it's issuing a bad check also on December 22nd, 2021. Man, this girl was just out writing them checks. Check was made or drawn in the state of Utah, is or exceeds $5,000. Again, that makes it a second-degree felony. All right, count 18. We're moving up in counts here, guys. Money laundering. In violation of Utah Code 76-10-19031CI, a second-degree felony, as follows. That on or about August 27th, 2028, 2021, in Summit County, state of Utah, the defendant did conduct a transaction knowing that the property involved in the transaction represents the proceeds of some form of unlawful activity with the intent to promote the unlawful activity. So there's your money laundering. So then that's the first one. So here we did the same thing, count 19, money laundering. This one was on or about October 12th through the 14th, 2021. Same thing. Conduct a transaction knowing that the property involved in the transaction represents the proceeds of some form of unlawful activity with the intent to promote the unlawful activity. And again, count 20, money laundering, on or about November 10th through 16th, 2021. Same charges. And that was a second-degree felony. And then there's another charge, count 20, money laundering also, on or about November 10th through the 16th, 2021. Same thing, second-degree felony. Count 22, money laundering. Same thing, on or about December 23rd, 2021. Did conduct a transaction knowing that the property involved in the transaction represents the proceeds of some form of unlawful activity with the intent to promote the unlawful activity. She just kept on. Count 23, money laundering, on or about December 23rd through 24th, 2021. Hey, it's almost Christmas, guys. And that was a second degree still. Count 24, another money laundering. Oh, we're at Christmas Eve, guys. December 24th, 2021. All right, Christmas Eve. She was writing some good checks. Count 25, communications fraud. In violations of Utah Code 76-10-18011E, a second-degree felony as follows. That on or about January 11th, 2022, in Summit County, state of Utah, the defendant did devise a scheme or artifice to defraud another or obtain from another money by means of false, fraudulent pretenses, representations, promises, or material omissions, and communications, directly or indirectly, with any persons by any means for the purpose of executing or concealing the scheme or artifice. The value of the property, money, or thing obtained or sought to be obtained is or exceeds $5,000. Count 26, pattern of unlawful activity in violation of Utah Code 76-17-4072AI, second degree felony. Well, that's kind of worded funny. I'm not a lawyer, but that's okay. I love English grammar, so I'll read it as it says. That between, on, or about June 29, 2021 and March 3rd through 4th, 2022 in Summit County, state of Utah, the defendant did commit prohibited conduct concerning a pattern of unlawful activity by receiving proceeds derived, whether directly or indirectly, from a pattern of unlawful activity in which the defendant has participated as a principal. This information is supported by the following probable cause statement. Background. The defendant met Eric Richins in 2009 while she was working as a cashier at Home Depot. They had a child in 2012 and married in 2013. At the time of the marriage, Eric Richins and his business partner owned a successful stone masonry business called C&E Stone Masonry, LLC. We can regard it as C&E from here on out. Eric Richins and the defendant entered into a premarital agreement, the PMA, whereby the defendant released and relinquished all rights, claims, or interests in C&E Stone Masonry, LLC. The PMA, which is the premarital agreement, provides that the following: Eric Richins' marriage to the defendant, C&E Stone Masonry, LLC shall nevertheless remain the sole property of Eric Richins. The premarital agreement further provided that the defendant shall have no rights or claim to the business except that if Eric Richins should die prior to the defendant, Kouri Richins, while the two are lawfully married, Eric Richins' partnership interest in the business shall transfer to Kouri Richins. In early 2019, the defendant used a power of attorney and obtained a $250,000 home equity line of credit in Eric Richins' premarital home. On Eric Richins' premarital home without his knowledge. On April 26, 2019, the defendant formed Kouri Richins Realty, LLC, Kouri Richins Realty, for the purpose of selling and buying real estate. The defendant was the sole member of the company. The defendant used the proceeds from the home equity line of credit to initially fund the Kouri Richins Realty and hard money loans to finance its ongoing operations. Oh my. Eric Richins first learned of the home equity loan on October 2020. The secret, originated, and continued existence of the home equity loan was sources of tension between the defendant and Eric Richins. The defendant informed Eric Richins that she would repay the loan and led Eric Richins to believe that she had repaid it. The home equity loan was not paid off on the date of Eric Richins' death. On October 13, 2020, Eric Richins consulted an estate planning lawyer. Eric Richins informed his lawyer that he wanted to protect himself in the short term from recently discovered and ongoing abuse and misuse of his finances by the defendant, and to protect his 3 children in the long term by ensuring that the defendant would never be able to manage his property after his death. 2020, Eric Richins executed several estate planning instruments, including a healthcare directive, durable power of attorney, pour-over will, and the Eric Richins Living Trust, which would be later called the Trust. In each of these instruments, he appointed his sister, Katie Richins Benson, his agent, fiduciary, or trustee to the intentional and purposeful execution of the defendant. He transferred his home and his interest in C&E to the trust. Eric Richins removed the defendant as his beneficiary of a $500,000 New York life insurance company policy on his life and designated the trust, which was his sister, as the beneficiary. The defendant did not understand this estate plan until after Eric Richins' death. Yeah, I think I remember that was when she didn't figure that out until she tried to break into the safe, if I remember that. And her and her sister-in-law got in a fight. Yeah. In the 5 months prior to Eric Richins' death, Kouri Richins Realty realized $170,000 in revenue, while its monthly debt services exceeded $250,000. It borrowed from over 25 lenders to support itself and service its debt obligations. Despite Kouri Richins Realty's existing debt and insufficient revenue, the defendant continued to use hard money loans to purchase 3 additional properties in November 2021. When the defendant closed on the 3 properties on November 30th, 2021, she added $1.1 million in high-interest debt to her already staggering and unserviceable debt load. By that day, she had already defaulted on 1 loan and was delinquent on several others. She continued efforts to borrow from new high-interest lenders to meet her existing obligations. By the end of 2021, the defendant stood on the precipice of total financial collapse. December 2021, the defendant contracted to purchase an unfinished mansion in Midway, Utah, using $2.9 million in high-interest debt due in 6 months, even though she lacked the financial ability to service the additional debt, refinance the debt, rehabilitate the property, or otherwise dispose of the property. The defendant was scheduled to close on the property on March 4th, 2022, the day of Eric Richins' death. She ultimately closed on it the next day. On the day of Eric Richins' death, K. Richins Realty owed hard money lenders at least $1.8 million, and the day after Eric Richins' death, it owed them nearly $5 million. At the time of Eric Richins' death, at least 3 insurance policies on Eric Richins' life existed, with aggregated death benefits of $1,350,000 and the defendant as the beneficiary. A 4th policy existed with a death benefit of $500,000. The defendant mistakenly believed that she was the beneficiary of that policy as well. A 5th policy existed that paid approximately $168,000 towards the balance of Eric Richins' mortgage. At the time of his death, Eric Richins' estate was worth approximately $5 million. The defendant, her family, K. Richins Realty, and C&E banked with America First Credit Union. The defendant also had a personal checking account with Navy Federal Credit Union, which included a $15,000 credit line. Section, the defendant submitted a falsified bank statement to Iron Bridge Financial in support of a mortgage loan application. This will go towards count 1, 6, and count 26. On July 7, 2021, the defendant, on behalf of K. Richins Realty, entered a mortgage loan with Iron Bridge Financial on June 29, 2021. In support of the loan application, the defendant submitted a purported America's First statement for K. Richins Realty dated May 31, 2021, showing an account balance of $210,000, $898,000.61. I'll get my money right in a minute. I'm not a counter. I like English. K. Richins Realty, America's First statement dated May 31st, 2021, shows an account balance of $15,609.93. C&E's America's First statement dated May 31st, 2021, shows an account balance of $210,898.61. The transaction description listed in the purported statement that the defendant submitted in support of the mortgage loan application are identical to the transaction description listed on C&E's statement. The purported statement that the defendant submitted is a compromise of the header of K. Richins Realty's actual statement and the body of C&E's statement. On July 2, 2021, while processing the mortgage loan, an Iron Bridge representative noted to the defendant, "When I ran your credit, it was lower than I expected. Looks like there are some delinquencies with regards to a few credit cards. I was just a bit surprised by that. I know you have a lot of money in the bank to cover expenses." 3 days later, the defendant explained, "I recently learned about all this as well, LOL. And then my husband tried to explain to me this was his doing a while ago. We're in the process of separation for one of many reasons, but this is one of them, to keep it short and sweet, LOL. It's been crazy to say the least." Oh my God. There's no evidence to suggest that this explanation is true. Wow. Okay, you go, Kouri. All right, check in with your banker. So the defendant submitted a falsified bank statement to Boomerang Finance in support of mortgage loan application, counts 2, 7, and 26. On August 4, 2021, the defendant, on behalf of K. Richins Realty, entered a mortgage loan with Boomerang Financial, Subrit, LLC. On August 2nd, 2021, in support of the loan application, the defendant submitted a purported America's First statement for K. Richins Realty, dated June 30th, 2021, showing an account balance of $702,831.96. K. Richins Realty actual America's First statement, dated June 31st, 2021, shows an account balance of $15,339.12. C&E's America's First statement, dated June 31st, 2021, shows an account balance of $702,831.96. The transaction descriptive listed on the purported statement that the defendant submitted in support of the mortgage loan application are identical to the transaction descriptions listed on C&E's statement. The purported statement that the defendant submitted is a compromise header of the Kouri Richins Realty, the actual statement, and the body of C&E's statement. Again, the same charge. So again, this happens again. So this is for Excel Financial Services. So this is count 3 through 5, count 8 through 10, and count 26. All the same information, August 21st. This is with Excel Financial Services. On August 12th, 2021, in support of the loan application, she submitted purported America's First statement for her personal account, dated July 31st, 2021, showing account balance of $694,730.15. And as we all know, she just took the body of C&E's statement and stuck it on her header. So, and then an Excel representative asked the defendant for a letter explaining her low credit rating. On September 12, 2021, the defendant wrote her low credit rating. That her low credit rating was because of a lady out of Seattle that had gotten a hold of her social security number. Okay, another lie, Kouri, because they say there is no evidence to suggest that this explanation is true. So she did that to them again. So now we're on. The defendant issues a series of bad checks and laundered money. This is counts 11 to 24 and count 26. On August 28, 2021, the defendant wrote a check number 271 from her Navy Federal Credit Union to the Kouri Richins Realty for $2,100. At that time, Navy Federal account balance was $0, and the line of credit was $13,694.50. The defendant deposited the check into the Kouri Richins Realty America's First account. At that time, the America's First account balance was $9,193.23. The defendant then transferred $250,000 from the America's First account to her mother. What? From the American. The defendant then transferred $250,000 from the America's First account to her mother. Okay, I read it right. And $13,775.85 to several creditors before America First could draw back the $2,100. America's First ultimately returned the check for insufficient funds. On October 12, 2021, the defendant wrote a check number 304 from Navy Federal Credit Union. And this, she wrote it to herself for $2,500. She had zero in the account because it was zero. The line of credit was $14,000. At that time, her account balance at America First was $505.49. The defendant then transferred $2,518.10 from the America's First account to several creditors before America's First could draw back the $2,500. America's First ultimately returned the check for insufficient funds. And again, November 11th, the same thing, Navy Federal Credit Union. This was for $3,000, and they returned the check for insufficient funds. November 12th, and they drew back $5,000, returned for insufficient funds. December 20th, 2021, check number 293, Navy Federal Credit Union. She wrote a check to herself for $4,000. She did have $51 in the account, but as we know, it bounced and it was returned for insufficient funds. December 20th, 2021, check number 294 from Navy Federal Credit Union to herself for $10,000 this time. Her account balance was $51.41. She deposited it into her Kouri Realty account. In her America's First. And guess what? It bounced. America's First ultimately returned the check for insufficient funds. Guess what? December 22nd, 2021. Check number 343, same thing. Wrote it to herself for $10,000. America's First ultimately returned the check for insufficient funds. All right, now we're down to the defendant fraudulently extracted $45,000 from her best friend. Counts 25 and 26. Oh, now this is going to get interesting. In late 2021, Kouri Richins Realty owned a home located at 299 East 100 South in Herbert City, Utah, on which the defendant owed $456,500 in 4 short-term, high-interest, hard money loans. 3 of the 4 notes secured by this property matured on January 7th or 8th, 2022. Beginning in October 21, the defendant unsuccessfully tried to refinance 299 East 100 South into a traditional 30-year mortgage. She planned to then sell or finance the property for her best friend. Oh my God. The best friend and her husband and 3 small children moved into the home. The defendant and her best friend signed a residential lease agreement with option to purchase, wherein the best friend agreed to pay defendant $2,900 per month in rent with an option to buy the home for $490,000. On January 11, 2022, the defendant's best friend caused 2 wires totaling $45,000 to transfer into Kouri Richins Realty account. Correspondence between the defendant and her best friend establishes that the defendant agreed to apply this money as a down payment on a long-term mortgage, supposedly closing on January 18, 2022. Oh, yeah, this just gets crazier. Immediately prior to the best friend's wires entering Kouri Richins Realty account, the account balance was $1,996. As soon as the first wire entered the account and before the second wire entered the account, the defendant transferred $19,299 of her best friend's down payment to a personal AF credit union account to cover a wire transfer of exactly $19,299 to Fund Fee, an entity with which the defendant had taken out a high-interest accounts receivable loan unrelated to 299 East 100 South. By January 19, 2022, the defendant had spent the remainder of her best friend's $45,000 down payment on expenses unrelated to 299 East 100 South. On January 19, 2022, Kouri Richins Realty account balance was $227.69. The 299 East 100 South refinancing did not take place in January 2022. The defendant was forced to enter an extension agreement with the largest of 4 hard money lenders on January 26, 2022. The 30-year mortgage lender revoked the proposed loan in mid-February and offered a less affordable hard terms. The defendant was thus forced to enter into another extension agreement with the largest hard money lender in February 16, 2022. The unpaid principal balance on that date was $347,715.86, and the extension agreement extended the repayment terms to March 8, 2022, 4 days after Eric Richins' death. Ultimately, one of the defendant lenders foreclosed on the property and evicted the defendant's best friend and her family. The defendant submitted a falsified insurance application on Eric Richins' life. This is count 26. On January 29, 2022, the defendant applied to TrueStage for an insurance policy on Eric Richins' life with a death benefit of $100,000, and the defendant named as a beneficiary. This life insurance policy became effective February 4th, 2022, 10 days before the defendant's attempt on Eric Richins' life and 1 month before Eric Richins' death. The defendant was able to apply for the policy because of her membership in PenFed Credit Union. Eric Richins had no affiliation with PenFed. The policy premiums were deducted from K. Richins Realty, America's First account. Eric Richins had no affiliation with this account. The address for Eric Richins provided on their applications is a P.O. box solely belonging to the defendant. The phone number for Eric Richins provided on the applications contained an incorrect digit. The signature of the application that purported to be Eric Richins' signature is a forgery. Wow. The defendant attempted to murder Eric Richins for pecuniary gain, count 26. The defendant occasionally employed Hayden Jeffs to assist her with renovating houses. On January 20th, 2022, the defendant text messaged Mr. Jeffs, "I did want to chat with you about something super random. Not now, at kid stuff. I'll call you tomorrow if that works." On January 21st, 2022, at 7:24 p.m., the defendant text messaged Mr. Jeffs, "Hey, today snuck away from me. Can I give you a call in the morning around 11:30? On January 22nd, 2022, at 11:06 a.m., the defendant text messaged Mr. Jeffs, "Got a sec?" Mr. Jeffs told law enforcement that he spoke with the defendant on January 22nd, 2022, and that the defendant asked him for fentanyl. The defendant told Mr. Jeffs that she wanted the fentanyl for a client who had back pain. Mr. Jeffs told the defendant that he would not get her fentanyl, and the defendant hung up on Mr. Jeffs. On January 22nd, 2022, at 5:35 p.m., after the phone call in which Mr. Jeffs declined to get F for the defendant text messaged Mr. Jeffs, "Have another one for you. Call me if you get a sec." Mr. Jeffs told law enforcement that during the second phone call with the defendant on January 22nd, 2022, the defendant asked him for this word, the P word. I'm going to stop saying these words because I'm not sure what I can and cannot say. This is something new that I need to learn. So back to this, the P word, the Michael Jackson stuff. Mr. Jeffs told the defendant that he could not get her the P word. The text messages from January 22nd, 2022 between the defendant and Mr. Jeffs were manually deleted from the defendant's phone. After that date, the defendant and Mr. Jeffs did not communicate ever again. The defendant and Mr. Jeffs had communicated regularly throughout the prior year. On May 31st, 2022, approximately 3 weeks after the defendant's arrest for the murder of Eric Richins, the defendant's mother text messaged the defendants, Mr. Jeffs running his mouth. The defendant occasionally employed Carmen Lauber to clean houses. Ms. Lauber told law enforcement that sometime in early 2022, before Eric Richins' death, the defendant either called or texted her to ask that she procure some F for the defendant. Forensic analysis of Verizon's record for the defendant's cell phones shows 746 SMS messages, 94 MMS messages, and 12 calls between the defendant's phone and Ms. Lauber's phone between January 1st, 2022 and March 15th, 2022. These messages were manually deleted from the defendant's phone. The defendant's phone contained messages to and from Ms. Lauber before and after this time frame. Ms. Lauber told law enforcement that pursuant to defendant's request for F, she contacted Nicole Cummings for an introduction to someone that would sell her F. Ms. Cummings confirmed that Ms. Lauber asked her for an introduction to someone that would sell Ms. Lauber F. Ms. Cummings elaborated that Ms. Lauber messaged her through Facebook asking to speak with her and that she called Mrs. Lauber shortly thereafter. A Facebook message from Mrs. Lauber to Mrs. Cummings on February 5th, 2022 at 1:30 p.m. asked, "Text me, I've got questions. Won't do it on this." In response to Ms. Lauber's inquiry, Ms. Cummings provided Ms. Lauber with phone number of a F dealer, Robert Crozier. Oh my God. Ms. Lauber's phone contained a contact for Mr. Crozier's phone number. The contact is labeled in a fashion that connects Ms. Cummings with Mr. Crozier. Miss Lauber told law enforcement that she contacted Mr. Crozier shortly after receiving his contact information from Ms. Cummins and asked to purchase F. Miss Lauber's phone records established that she texted Mr. Crozier on February 10th, 2022 at 8:52 p.m. Miss Lauber told law enforcement that she met Mr. Crozier at the Maverick gas station in Draper on February 11th, 2022, and purchased from him 15 to 30 round light green blue pills, which she understood to be F. What is wrong with these people getting stuff off the street? Miss Lauber's phone data showed that she called Mr. Crozier several times on February 11, 2022, between 5:19 and 6:52. Miss Lauber stated that these calls were coordinated the specific time of the F purchase. Miss Lauber's phone data also shows that she text messaged Mr. Crozier several times beginning at 7:18 while she was located at the Maverick. Mrs. Lauber's phone data shows several text messages between the defendant and Miss Lauber on February 11, 22. The messages began at 3:42 while Miss Lauber was at her home in Heber and continued at 6:23 as she passed through Linden on her way to the Maverick gas station on Draper. The defendant and Miss Lauber text messaged at 7:18 while Miss Lauber was located at the Maverick and text messaging with Mr. Crozier. The messages continued at 8:20 p.m. as Miss Lauber passed through Lehigh on her way back to her home in Heber and concluded at 8:56 while Miss Lauber was at her home in Heber. Miss Lauber told law enforcement that she delivered the pills that she purchased from Mr. Crozier to the defendant in a hand-to-hand transaction in the driveway of Mrs. Lauber's home in Heber on either February 11th, 2022 or February 12th, 2022. Mrs. Lauber's phone data shows that in addition to these text messages, the defendant and Mrs. Lauber exchanged on February 11th, 2022. The defendant and Ms. Lauber exchanged text messages on February 12th, 2022 at 9:58 and 2:49. Ms. Lauber was located at her home in Heber during both exchanges. A certain diner. Okay, we're going to get this, guys. We're on page 15 of 19, which I think it actually ends at 18, so we're almost there. A certain diner in Camas, Utah, the diner, opens daily at 7 a.m. At 8:53 on February 14th, 2022, isn't that Valentine's Day? The defendant placed a 1-minute phone call to the diner. The defendant and Eric Richins' joint bank account statement showed $41.29 purchased at the diner on this day. At 9:41 a.m., the defendant text messaged her paramour, headed that way. At 9:49 a.m., the defendant messaged him a screenshot of a navigation application on her cell phone showing her current location on SR 32 and Camas and her projected arrival at an unknown destination at 10:49. At 11:09, Eric Richins placed a 2-minute phone call to the defendant. At 11:27 a.m., Eric Richins text messaged a photograph to defendant. The photograph has been deleted from both sides, or both the defendant's and Eric Richins' phone. At 11:33 a.m., Eric Richins text messaged the defendant, "I'm going to lay down for a bit. If I don't start getting better, I'm going to head to the hospital." 1 minute later, the defendant responded, "Geez, is it that bad? Need me to come home? Go to take a nap and call me when you're up." 5 minutes later, at 11:39, activity recorded on Eric Richins' phones and associated devices ceased. Activity did not resume until nearly 2 hours later at 1:32 p.m. So, there's where you get the F. There's where the purchase at the diner of the food that she had, or the Moscow Mule that she had given to him. He was feeling bad. Okay. Things are adding up. She wants him to just go lay down, take a break, do nothing, and then everything cease at 11:39. Okay. All right. Reading on. At 1:43, Eric Richins text messaged the defendant and asked, "Are you home?" The defendant responded, "No. In Provo, waiting for my cabinet installer guy. Are you home?" At 1:45, Eric Richins responded, "In the office. I've been sleeping out here." Okay, so that must have been food. That wasn't the Moscow Mule thing. We're not there yet. Okay, I'm ahead of myself. In the office. I've been sleeping out here. Eric Richins' office was in a freestanding structure behind his home. At 1:59 p.m., Eric Richins called Kouri Wright a close friend. Mr. Wright could hear fear in Eric Richins' voice and tell that Eric Richins was scared. At 2:11 p.m., Eric Richins called Josh Kays, another close friend. Mr. Kays was struck by the tone of Eric Richins' voice and said that he seemed different, down, and somber. That word, if you're reading along, the O word, opioids, which I think that is fine to say, including the F, can cause allergic reactions and pseudo-allergic reactions to including hives. Eric Richins did not have any food allergies. The defendant and Ms. Lauber exchanged 30 text messages on Valentine's Day 2022. On June 18, 2022, 3.5 months after Eric Richins' death, the defendant text messaged her best friend about this incident. The defendant wrote, "It was Valentine's Day, and Eric and I were both working from home that day, and I ordered lunch from the diner. He never broke out in hives or used an EpiPen. I was fucking with him. He said the sandwich hurt his stomach, so he was going to take a nap. No hives, no EpiPen." All right. Okay, Kouri, you're not helping yourself. On August 22nd, 2023, nearly 4 months after the defendant was arrested for the murder of Eric Richins, the defendant discussed this incident in 2 phone calls. In a phone call with her mother, the defendant confirmed she was the person who picked up sandwiches from the diner on Valentine's Day. She said, "We ate in the office." On a phone call with her brother, the defendant discussed buying lunch at the diner that day. The defendant murdered Eric Richins for pecuniary gain. Count 26. Ms. Lauber told law enforcement in late February 2022 the defendant told her that the F pills that she previously provided were not strong enough and asked that she procure some stronger F. Ms. Lauber initially stated that the defendant specifically asked for some of the Michael Jackson stuff. Okay, I'm not making this up. That is what this says. During the second request for the F, but subsequently conceded that the defendant may have referred to the Michael Jackson. During her earlier request for the F, Michael Jackson died of a propofol overdose. On February 26, 2022, Ms. Lauber sent Ms. Cummings a Facebook message asking that Ms. Cummings again provide her with Mr. Crozer's phone number. Later that same day, Ms. Lauber contacted Mr. Crozer and arranged to purchase additional F from him at the same Maverick gas station in Draper. Ms. Lauber's phone data shows February 26, 2022, beginning at 2:25 p.m., defendant Ms. Lauber exchanged several text messages. Again, this goes to the same thing. She did it. Exchange text message while she was located in the Maverick. 3:21 on March 4th, 3:21 a.m. on March 4th, 2024. 2. The defendant called Summit County Dispatch and reported that her husband, Eric Richins, was not breathing. He's cold. He doesn't have a pulse. 10 minutes later, Summit County Emergency Medical Services personnel and Sheriff Department arrived at Eric Richins' home. They found Eric Richins on the floor at the foot of his bed and performed life-saving measures, but ultimately declared him deceased at 4:58 a.m. EMS personnel thought that he'd been dead a while and noted that he was asystole the whole time. I don't know that word. I apologize. A word I need to learn. While EMS personnel were attending to Eric Richins, the defendant told law enforcement that she and Eric Richins had a drink together at 9 to celebrate something at work tomorrow. A year later, the defendant told law enforcement, "I made Moscow mules in the kitchen and I brought them into our bedroom." The defendant further said that they drank the Moscow mules sitting on the bed. Sometime after Eric Richins' death, the defendant wrote in a journal that on the night of Eric Richins' death, she and Eric Richins went to the kitchen and both started grabbing ingredients for Moscow mules and a lemon drop. We finished talking, made our way back to our bedroom, and brushed our teeth. A pathologist at the office of the medical examiner performed an autopsy on Eric Richins and concluded that his immediate cause of death was drug intoxications, the F. The medical examiner determined that the level of F in Eric Richins' blood was 1.5, which I guess is 15. There's not a point there. 15 milliliters, which approximately 5 times a lethal dose, and that his gastric fluids contained an additional 20,000 milligrams of F. The medical examiner determined that the byproducts of the F found in Eric Richins' gastric fluid were typical of illicit F, not medical grade F. The medical examiner determined that the F found in Richins' body had been orally ingested. Wow. That's okay. We're learning as we go, guys. The medical examiner also found 16,000 milliliters of quintiapine in Eric Richins' gastric fluid. Quintiapine is an atypical antipsychotic medication used for the treatment of schizophrenia, bipolar disorder, and major depressive disorder. It is widely used as a sleep aid due to its sedating effects. The defendant told law enforcement that at the time of Eric Richins' death, she had a prescription for quintiapine. On the night of Eric Richins' death, the defendant told law enforcement, "We eat gummies, sometimes the THC gummies. Sometimes Eric will eat gummies before he goes to bed. It didn't seem like he did, though." A year after Eric Richins' death, the defendant told law enforcement that she saw Eric Richins take a THC gummy in the bedroom after drinking the Moscow Mule. The defendant then clarified, "I didn't actually see him take it. He told me he took it. And then he had to have taken it while I was making the drinks." In explaining to law enforcement how the defense thinks the F got into Eric Richins' body, the defendant said, "I honest to God think it was one of those gummies, 100%. After the defendant arrest for the murder of Eric Richins, the defendant's mother asked the defendant if she was sure the F came from a THC gummy. The defendant replied, "That's what I'm banking on, yes." Oh, Kouri, you're digging your hole, baby. The medical examiner did not find any THC in Eric Richins' blood or gastric fluid. The state toxicology lab tested the THC gummies in Eric Richins' home at the time of his death and determined that they did not contain F. The defendant told law enforcement that she went to bed with Eric Richins in the bedroom at approximately 9:30 to 9:45 p.m. on March 3rd, 2022, and shortly thereafter went to one of their children's bedrooms to sleep with the child because the child was having nightmares. The defendant said she awoke in the child's bedroom at approximately 3 a.m. on March 4th, 2022, and returned directly to the bedroom. The defendant said she was asleep in the child's bedroom the entire time. The defendant told law enforcement that when she left their bedroom approximately 9:30, 9:45 to go to the child's bedroom, she left her cell phone plugged in next to her bed and did not take it to the child's bedroom. The defendant told law enforcement that upon returning to their bedroom, she felt Eric Richins and he was cold to the touch and not breathing, and she immediately called 911. Summit County. I'm so sorry for that bark, guys. I'm so sorry. I'd never even thought about that. This is learning curves. Yeah, dogs are part of my life. They're in my background. I do apologize for that. That might have been a shocker to a few people. So, carrying on, as I was reading, you might hear another bark because the dogs are playing, and that's just what happens at my house at 1 o'clock in the morning. So, Summit County Dispatch received her 911 call at 3:21 a.m. on March 4th, 2021. So she let him lay there for a good while. Forensic analysis of the defendant's cell phone shows that it was unlocked 6 times between 3:06 a.m. on March 4, 2022 and 15 minutes later, 3:21 a.m. when the defendant called 911. So from so this is telling me, okay, see, keep reading, Sheila. Keep reading. This analysis also shows that in the 13 minutes between 3:08 a.m. and 3:21 a.m., the defendant's phone or an associated device traveled approximately 378 feet. The defendant used several cell phones, including burners. The cell phones that the defendant primarily used leading up to and shortly after Eric Richins' death indicates that a significant amount of information was manually deleted for it, particularly between January and mid-March 2022. Forensic analysis of one of the defendant's cell phone shows that by April 16, 2022, 3 days after law enforcement first informed the defendant that Eric Richins died of an F overdose, the defendant's cell phone was used to access website articles with the following titles, among others. Utah State Prison. Let me quote. Utah State Prison dash Tampanagos Women Facility, end quote. Quote, what happens to deleted text messages, question mark, end quote. Quote, cause of death usually does not impact life insurance payment, end quote. Quote, how do police and forensic analysis recover deleted data from phones, question mark, end quote. And, quote, signs of being under federal investigation, end quote. Oh, what is wrong with her? Forensic analysis of some of that same cell phone also shows that by June 6, 2022, the defendant's phone was used to conduct the following internet searches, among others. Quote, can you delete? Oh, that's a big typo word, but I read typo. And that says everything off. So it says, can you delete everything off an old, another typo, iPhone without actually having another typo? It. And then, Kouri, you need to learn how to text better on your old iPhone there. Then she Googled, she internet searched, I'm not sure if she used Google, quote, women Utah prison. She also looked up, can cops, period, uncover deleted, period, messages, iPhone. Can cops force you to do a lie detector test? All right, here we go. We got another one. Quote, if someone is poisoned, what does it go down on the death certificate as? Another quote. How long does life insurance companies take into .pay? Okay. And, quote, what is a lethal dose of .f dot? Okay. Put all the periods in there. I'm not sure why you do that. I guess your spaces are periods. I don't have that problem texting. I just have problems of it not coming out the right word. I do read typo. I also speak it in a lot of my text messages. On May 28, 2023, the defendant was arrested for the murder of Eric Richins and received a copy of the charging document and probable cause statement. The probable cause statement referred to Ms. Lauber by her initials and contained many of the facts presented above. On a jail call that day with her mother and brother, the defendant said that Eric Richins asked me to ask Ms. Lauber for pain pills. The defendant never mentioned asking for pain pills for Eric Richins or from Ms. Lauber during 3 hours of police interviews, and indeed insisted that Eric never took illicit drugs or pain medication other than an occasional over-the-counter medication. And this is the last count. The defendant fraudulently claimed insurance benefits from Eric Richins' death, count 26. The defendant was the beneficiary of 2 insurance policies on Eric Richins' life issued by TrueStage, with an aggregated death benefit of $350,000. One of those policies issued on May 12, 2017, and the other on February 4, 2022, 1 month prior to Eric Richins' death. On April 28, 2022, the defendant submitted a claim against the policies. On June 7, 2022, TrueStage learned that Eric Richins' cause of death was drug intoxication F. On June 14, 2022, TrueStage left a voicemail with the defendant requesting a copy of any prescription Eric Richins had for F. Later that same day, the defendant informed TrueStage that the F was not prescribed and that she didn't have any idea how Eric Richins obtained the F. The next day, on June 15, 2022, the defendant reiterated to TrueStage that she really didn't know where Eric Richins obtained the F. Okay, I was wrong. There's one more count. Pattern of unlawful count. This was count 26. The pattern of it says pattern of unlawful conduct. Read, Sheila, read. The pattern of unlawful conduct is predicated upon the offense charged in count 1 through 25 above, and the herein uncharged insurance fraud, attempted aggravated murder, and attempted murder offenses. Authorized for presentment and filing June 27, 2025, Margaret H. Olson, Summit County Attorney Brad Bloodworth, Chief Prosecutor. Defendant's last known address, Summit County. Oh, sorry about that. I think the dogs are probably done. And as I was saying, the defendant's last known address is the Summit County Jail, as we all are well aware of. So that's what I wanted to go over. So what are your thoughts? She has all these new charges. There are going to be, let's see, hang on, I have it. There are 5 counts of mortgage fraud, and that is here we go. We're going to show this tab instead so y'all can see what I'm looking at. So this is her newest charges. She is mortgage fraud. She's got 5 counts, second-degree felony. Money laundering, 7 counts, second-degree felony. Forgery, 5 counts, third-degree felony. Issuing a bad check, there's 7 counts, third-degree felony. Communication fraud, 1 count, and that's a second-degree felony. And a pattern of an unlawful activity, 1 count. So that's where we stand. So those are the new charges that have been added on to Kouri Richins. And we are going to follow this trial. This is something that I do have interest in. We may do a couple deep dives on this to find out more facts and do some more learning. I'm very interested in this. We may go back and do some rewatches of when she was arrested, the body cam videos and stuff like that. So take your time and enjoy the rest of your night, day, morning, wherever you're at. And don't mind, give the video a like, thumbs up, subscribe. And thanks for stopping by. Enjoy the rest of your evening, guys.
And I'm a real-time crime professional.